Having a will is not the same as having an estate plan. Hi, my name is Alec Osland, and I'm an attorney at the Yanowitz law firm, where we've been assisting Minnesota families with wills, trusts, and probate for over 3 decades. A will is not an estate plan. It is, though, part of an estate plan. A will is a tool that we use in the estate planning world to identify where our assets go when we pass away, and it allows us to pick who's in charge of gathering those assets and making sure they end up with the right beneficiaries. And a will also allows us to nominate guardians of our minor children. That being said, an estate plan may include a will, but it's also going to include other important items and documents, such as it may include a trust, power of attorney, healthcare directives, beneficiary designations, transfer on death deeds, and business assignments, just to name a few other tools that can be in an estate plan. A trust is going to allow you to avoid probate court and allows you a more restrictive way to transfer your assets in a way that is more efficient and cost effective than a will-based estate plan. As with trust-based estate plans, we completely try to avoid probate court if we can. And with that trust, we may retitle some assets in the name of the trust now while you are alive. And with other assets, we may designate they go to your trust upon your death. A power of attorney is going to allow you to designate an agent who can essentially make all non-medical decisions on your behalf while you are still alive. So a power of attorney, it ends when you die. A healthcare directive allows you to appoint an agent to make your healthcare decisions if you are not able to make your healthcare decisions on your own. A beneficiary designation, it allows you to list certain beneficiaries on your financial accounts, and that instructs the institution that when you pass away, the institution should release the funds to the beneficiaries that you have listed on the beneficiary designations. A transfer on death deed is very similar to a beneficiary designation, but it is a document that strictly is associated with your real estate. A transfer on death deed must be recorded with the county recorder where your property is located. A business assignment allows you to transfer interest in a business such as an LLC to a designated beneficiary upon your death. All of these tools work with each other to accomplish the goals that you have, and all of them together make up your estate plan. So, what should you do? You should make sure that, one, you have an estate plan in place, and if not, you should reach out to an estate planning attorney. If you currently have an estate plan in place, well, this video can be a good reminder to look at it. Does your estate plan accomplish the goals and wishes that you have currently? It may have accomplished them when you set this up, but family dynamics may have changed, relationships may have changed, so your current documents may not make up the goals and wishes that you have with identifying what happens with your assets when you pass away. It is important that you work with an attorney in a law firm that is experienced with estate planning. As I tell people, there's no trial runs with an estate plan. We don't know if it was done correctly until you're dead, and by that time, it's too late to change anything. So I'd like to thank you for joining me today. Make sure you subscribe to our YouTube channel to find out when we post another video. Thanks, and have a great day. Bye.